Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. I apologize. So if you were watching the Murdaugh murder stream earlier, I had some audio issues. I had to restart my equipment, but I'd forgotten that I would have to restart my equipment. So instead of being 2 minutes late, like fashionably late, I was like black people late. God. Oh, not good. Wait, I'm on YouTube. Instead of being 2 minutes late, I was 8 minutes late. Is what I meant to say. What's up, guys? Okay. We've got some stuff to cover today. All right. This is what we've got to do. What the hell is this? We've got some stuff to cover today. We've got some big topics. The big topics are Russell Greer versus Joshua Moon. This is a lawsuit we were looking at a while back. Russell Greer is suing Joshua Moon for contributory copyright infringement. And I think intentional infliction of emotional distress and maybe defamation. And his lawsuit is absolute shit. And this is the same again. No, this isn't again for Greer. This is the same suit that's been going on for a really long time. It got delayed because it got appealed. And the appeal just actually went to oral argument. For whatever reason, Court of Appeals really wanted to hear the oral arguments on this case, even though, I mean, it's insane. The entire case, the premise of the case has been insane from the start. But so what we've got, though, is the oral arguments happened just the other day. And those, well, we're going to listen to them. It's federal appeals court, so there's no video, but there is audio of those. And I figured we might want to check in on the lawsuit itself and see. I was going to pull up and see. I don't know that there's any particular documents that are super useful, but we can take a peek at where the case is. And then the other thing to talk about is the Eliza Bleu, which I've been not talking about for a bit, and some people have called into question my position on it because I haven't been super clear. I haven't been shouting from the rooftops about this stupid case, or about this this incident. Because one, I don't have any malice towards Eliza Bleu. I barely interacted with her, and while I do trust my friends, the Quartering and Brittany Venti, and I have nothing, no reason to disbelieve them or anything. I also don't tend to get into other people's fights unless I really know what's going on. And I haven't been following it because, frankly, I thought this thing was going to be like a one and done kind of 24-hour deal. Well, it turns out it's not. This is a thing that's going to keep going for a while. So now it's time to talk about Eliza Bleu. That we're probably going to do on Rumble after the first hour. Bifron says Venti hates Nick. Oh, I don't think so. Venti and I always get along just fine. What are you talking about? But yeah, so we're going to probably tackle that one in the second hour. And then those are the big stories, but then we've got some What the Fuck Wednesday to talk about. Yeah, and Eliza didn't just stop at Venti and the quartering. She's also hit Yellow Flash and a lot of other people too. And it's crazy how bad, like, what is being flagged is actually kind of insane. So I guess we're gonna talk about that and talk about what she's actually doing. Um, because it's not good. It's not good stuff. Not too good. Let's see. I'm mm, 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 mm. Let's see. I'm trying to find the actual paper copies of appellant's reply brief. We have a response. Where's the fucking brief on this? Anyway, I'm trying to pull up the original. Yeah, the Russell Greer documents. Oh yeah, but sorry, I got sidetracked. What the Fuck Wednesday, of course, we'll do at the end of everything. It'll be kind of a palate cleanser. And to my locals chat, if you have any submissions for What the Fuck Wednesday, you can put them in the comment section of the current live stream live chat that we've got. If you put it in the chat, it's going to scroll away and I'm going to miss it. So I'd prefer if you could put it in there. I think you might have to do that on a mobile device. I'm going to talk to locals about that. It's a new issue for me that I didn't know about before. Okay. So we'll do all this. And I'm going to bring a friend on as well for this who is has some knowledge in the intellectual property sphere, because I think, both of these cases involve intellectual property. And so that's what we're going to talk about here. Where is it? Extend time to file, docketing statement, mediation conference, court's own motion, blah, blah, blah. Motion filed by Greg. Extend time to file again. Where is your fucking document, Greer? Appellant petitioner's brief. Here we go. 91 pages. Come on, Russ. This thing isn't it. The important part is not 91 pages. But we're not going to go through this whole thing. We're going to get a gist of what's going on. That's the trick there. And we'll figure that out. Okay, so housekeeping stuff while we wait for our guest to pop in. I just sent them the link. It's my fault. But I am covering the Alec Murdaugh murder trial. I was going to cover dumpster defenders, but then they decided that would not be streamed and broadcast anywhere. So stuck dick in hands on that one. So we turn our attentions to South Carolina, where a crazy case has developed surrounding Alec is how it's spelled Alex Murdaugh and it's pronounced Alec Murdaugh. So the guy's name is a lie. I don't know how anyone can trust him. But anyway, this guy is a solicitor. He was a solicitor general of South Carolina. There's a boating accident, and because of that, it looked like some financial crimes might be exposed. And then all of a sudden, blam, 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 wife and adult son are dead. He is charged in their double murder. And the interesting thing is the state seems to have basically no case. They don't have any physical evidence linking him to the crime. They just have circumstantial evidence. That's all they've got. Yeah. That's what they got. So it's really weird. They're going to build the entire case off of the circumstantial evidence. The difference between direct and circumstantial evidence is direct evidence is someone witnesses something, you have a document, you have a test, you have a physical thing that you can point to that shows something happened. Circumstantial evidence is, well, based on this set of factors, we can infer this thing occurred for each fact, which is a little bit uncomfortable for criminal cases because we want proof beyond reasonable doubt. And if all you've got is circumstantial evidence, that doesn't mean you can't do it. It just means it's tougher to conclusively prove something because there's no witness to it. And there's no blood spatter. There's no DNA evidence. There's nothing to link this actual criminal act of him pointing a gun, pulling a trigger, and then for whatever reason, grabbing a completely different gun and pulling the trigger on another person. So it's kind of weird. But anyways, I would like to welcome to the stream my very special guest and good friend. How's it going, Kurt?
It's good to see you.
Hey, buddy. How you been?
I've been good.
Good.
Life is good. Streams are good. Everything is good. Well, except for the fact that I started doing my taxes and I'm going to have to write a big ass check.
I don't want to talk about that. I don't want to. I'm getting pre-TSD. I'm still suffering from last year's taxes.
So other than the big ass check, things are going fine.
God, I hate tax season. I hate it. I hate all the work that you have to do. Even if you hire an accountant, you still have to do a bunch of work. Like you still have to gather all this information. They're like, "Oh, tell me everything you did." It's like, "Well, that was your job." Like, but I didn't know what you did. It's like, well, why not? Why weren't you there? Some kind of loser. Anyway, so all right, Kurt, I've got 2 intellectual property issues to tackle tonight. And I don't know if you were listening, but I
was listening.
Okay.
I was listening and patiently waiting for the invite.
Sorry,
for you to respond to my text messages and to be acknowledged in any way.
I don't do that. You got to know this, Kurt. I don't do that, but it's not personal because I don't do that to anybody.
I know. I know you're universally a bad friend. Yes, I understand.
Literal worst. But anyway, so we do have this first topic, which we're going to do is Russell Greer versus Joshua Moon. Do you remember this case? It is actually filed in 2021. It's been a long time.
You'll have to refresh my memory, man. The names are not striking me familiar, but maybe if you told me some facts, it'll click.
Okay. Well, Joshua Moon is the owner of Kiwi Farms.
Okay.
Russell Greer is the owner of being a retard.
Okay.
These are 2 very, very important things.
But the owner of Kiwi Farms is also a retard.
Some would say.
Yeah, they run a retard farm.
Yeah, they're tard wranglers.
So they're really lost twins. And like Cain and Abel are bitterly fighting.
They look the same. Now that I think about it, Josh, you've been called out. Yeah. Okay, so anyway, Russell is, you might remember Russell Greer. He is the guy who sued Taylor Swift 5 times. Ariana Grande, Katy Perry. He has Mobius syndrome, so his face is fully paralyzed and his lips don't close together.
Is he the same guy that paid for the prostitute at the Bunny Ranch and got the limo and wore a tux all day to the Walmart? Okay, yep. I'm on board.
And brought her to Olive Garden, which of course, I mean, when you're going to go to the Bunny Ranch and rail out a prostitute named like Kiara or something, what you do first is you bring her for a carb-laden meal.
Yes.
You want her to keep her energy up for the heavy session you're about to do in your disgusting tux. Okay, so yes, that's Russell Greer. Now, he is suing the Kiwi Farms for what he calls contributory copyright infringement.
Okay.
Now, this is because a user of the Kiwi Farms has uploaded, I believe, or is alleged to have uploaded a copy of Russell Greer's book, Why I Sued Taylor Swift.
Okay.
And the Kiwi Farms did not take this down. So he has sued them for contributory copyright infringement, which I'm not an IP attorney, but that's not the standard for contributory copyright infringement.
Right. Well, you're first to Section 230, right? Because they're not the publisher of anything that they don't contribute to. So
Right.
the best case that I remember recently that dealt with this issue was the shitty media men list that was circulating around, where there was that list of purported men in Hollywood that were shitty, and
Right.
so there was this Excel spreadsheet, what it basically was, and people were like, "Well, just go on there and tell us all the people that were shitty." They sued the people that created the template or created the master document, and they tried 230. The courts rejected that because they're like, well, no, actually, in your particular case, you're specifically soliciting this particular information. You are saying to people, please come onto our list and tell us about the shit in media men.
Right.
So this is a defamation case, not contributory copyright, but like it's the same idea, right? That you're soliciting specifically this. So the only way that you can really get to that is to show that they had some more specific sort of thing beyond just post whatever pleases you, and because otherwise you can't get past the 230 issue.
Right. And so the way another factor sorry, to link back what you were saying, contributory copyright infringement requires not merely the ability to commit copyright infringement on a platform. The platform has to encourage or
Solicit.
facilitate. Yeah,
Yeah.
encourage, solicit, facilitate the copyright infringement. Not merely make it possible that it could
Yeah.
happen, because otherwise, anytime copyright shit hit any platform, they'd all be suable for contributory copyright infringement. It's
Right.
merely the ability to upload is the ability to infringe copyright. And to clarify for some people in the chat who may not know this, the DMCA has nothing to do with a copyright infringement claim. The DMCA is a separate issue, and it is basically a short circuit way to allow to actually protect platforms that take down copyrighted material, but it doesn't actually protect anybody or enable anybody in a copyright suit. If you don't file a DMCA, you can file a copyright infringement claim. If you do file a DMCA and it's taken down, you can still file a copyright infringement claim. That doesn't have any bearing on whether or not you actually have copyright infringement going on. So that's kind of an issue here, is because Kiwi Farms did ignore the DMCA or said it was invalid or whatever. They refused to honor the submitted DMCA request. But that doesn't have any bearing on whether or not they're contributing to the copyright infringement or if the copyright infringement is valid at all.
Right.
At least that's my understanding.
Right. That's basically right.
Okay.
Yeah. So I don't really see how this works unless they can show some more specific tie beyond generally this is a platform for people to write whatever trolls they want. Because if you could, as you point out, basically every platform would be liable. So
Right. So we're at the U.S. Court of Appeals, and we're going to take a quick breeze through of the statement of the issues, the statement of the case, just to see what we've got. And then I figured we'd listen to oral arguments. It's not super long. It's appeals court. So what, like 10 minutes aside. And then we'll just kind of take a look at where the case is, and then we'll move on to Eliza, if that's cool with you, brother.
Works for me.
All right. So the statement of the issues: did appellant Greer state a claim for copyright infringement in his pro se complaint? Did he state a claim for contributory copyright infringement or vicarious or direct copyright infringement? So just throwing darts and hitting all the bases here.
Yeah.
For both
direct as I did it. Contributory is basically I'm, a partner in it, and vicarious is basically I'm one step removed from it. So yeah. Basically every possible way of being related to this.
For both his copyright claims and his state law claims, did the district court err by failing to grant Mr. Greer leave to amend after it identified what it viewed as the insufficiencies in his initial pro se complaint? So they said he failed to state a claim, dismiss it out. And then he says he did state a claim, or in the event that he did not adequately state his claim, should he have been granted leave to amend? And I think what the court basically said, the district court, if I remember right, it's been a while, but it was that amendment will not cure the issue. This is a key factor in pleading and amending pleadings. You get lots of leave to amend pleadings from the court. They want well-pleaded cases to come in because they want clear issues to be brought before the court that can be resolved by the court. But if they look at an issue and say there isn't a deficiency in pleading, there's just no issue that the court can resolve, then amending the pleading doesn't matter. Like saying it a different way doesn't work. And if
Right.
your issue is you lack any allegation to link Kiwi Farms as an entity or Joshua Moon as a person to the contributory copyright infringement, then the case can't be brought no matter how you word it. There's you have to make a claim that shows that he did something, and they haven't. I mean, that's the problem. The Kiwi Farms, for one, isn't a sentient entity that is making a decision here. And so Joshua Moon would have to personally have somehow helped this along. And there's no evidence of that, according to the district court. So for the first issue, Mr. Moon and Kiwi Farms asserted in their motion to dismiss that Mr. Greer had failed to state a claim of copyright infringement. Mr. Greer opposed. District court granted the motion. For the second issue, Mr. Greer sought leave to supplement twice. The district court denied both motions without discussing whether Mr. Greer should have been given leave to amend so that he could address, after reviewing its order, what the district court saw as deficiencies in Mr. Greer's initial pro se pleadings. Now, a brief procedural thing. Greer did file this pro se, but his appeal is actually taken up by a group of people who really legitimately despise free speech and are extremely pro DMCA and copyright strike heavy. It's a legal defense group that does specifically these things, and they fight for copyright very, very heavily. So both issues were pressed or passed upon below. So statement of the case. DMCA, as an infringement dispute between a copyright holder and a website operator, this appeal has significant implications for the 1998 DMCA. By way of background, Congress's approach in the Copyright Act has been to define the scope of a copyright holder's exclusive rights in broad terms. Then Congress enacted carefully crafted exceptions to copyright owners' exclusive rights in order to advance specific public policy goals. Among others, these public policy goals include helping librarians and archivists to organize and preserve knowledge, as well as to accommodate the needs of the blind and disabled persons. I mean, there's some other goals, though, right? Like there are other goals like commentary, criticism, transformative use, I think, maybe. I don't know. When it comes to infringement online, the exclusive rights most often at issue for posted materials are the public display and public performance rights, citing section 106.4 and 106.5. As with other exclusive rights granted by the Copyright Act, the Act's general approach, quote, is first to state the public performance and display right in broad terms, and then provide specific exemptions for educational and other nonprofit uses.
So far, so good.
The result is the Act's capacious definition of public performance and display, and accordingly, its capacious definition of infringement, citing Spansky Enters, or is that entertainers?
Entertainers, I think.
Yeah, that's got to be an abbreviation. Versus Telewizja Polska S.A. Obviously, you know this case, right, Kurt? You know this one?
This random DC circuit from 2018? I do not know.
We do have a thank you, Art. We have an image of Russell Greer here for the chat, so everybody knows this is Russell Greer. Again, he does have Mobius syndrome, so his mouth does not close. You may be tempted at juvenile chat that you are to make fun of Mr. Greer for his Mobius syndrome and his paralyzed face. But let me just stop you from that. That would be cruel. What you should make fun of Mr. Greer for is his abhorrent personality. That's the trick. That's the real spice of this man. Not good. The Act contemplates a broad interpretation of the concept of public performance and display, citing Video Views Inc. versus Studio 21. The definitions of a copyright owner's exclusive rights intentionally have a breadth sufficient to create property rights over the use of various transmission technologies. Basically, that means that you have a tangible right in the transmission, like through an airwave or an internet wire or something of the thing, not just a physical medium. Reminding people that when copyright law was created, we had physical transmission of documents very specifically. And then later, things like radio, television, the internet would be invented and created. So that's that the law had to grow with it. In response to growing usage of the internet and substantial implications of copyright law for the explosion of online activities, Congress passed DMCA in 98. Title II of the DMCA, formerly called the Online Copyright Infringement Limitation Liability Act, codified a newfound exception to copyright holders' exclusive rights, an innovative notice and takedown process at 17 U.S.C. 512 that was intended to respond to a number of looming crises for both copyright holders and website operators caused by the interaction of the internet and copyright law. For website operators, if a third party posted a photograph, book, video, or song to their website, they could be liable for copyright infringement even if they didn't know about it, citing Bell versus Wilmot Storage Services. Indeed, copyright infringement is a strict liability tort. Merely just leaving the materials posted by someone else online, even without proof that anyone saw it, could lead to liability for the website operator. That result seemed to Congress unwise.
Yeah, this is why the DMCA and the Communications Decency Act were written, because there were decisions from the courts that did exactly the opposite of that. In the case of the Communications Decency Act, it was Stratman Oakman versus Prodigy, I think was the case, if memory serves correctly, that went the other way, and then they wrote the Communications Decency Act to overturn that. And so basically, yeah, this is not a surprise. It's like, well, we got to do something different. Okay.
What's really interesting is they're talking about the history of the DMCA, but they're citing a case from 2021 with this quote: "Indeed, copyright infringement is a strict liability tort." Now, my bullshit meter is going off on this.
Yeah.
This is, I can almost guarantee you, without even knowing this case, that is a quote of a much older case within this 2021 case. What do you think?
Or even if not the case, even if not, it's a sentence out of context. Like,
Yeah.
it's a sentence dealing with a different scenario, and the court wrote, "Indeed, copyright is strict liability tort." Well, not necessarily in every single context known to man. In the case they're talking about, sure. In that other case, not necessarily. But it's probably not correct.
Right. And what they're saying up here, they could be liable for copyright infringement even if they didn't know about it. If a third party posted to their website, that seems to run afoul of the safe harbor provisions of 230 and the Copyright Act. So I'm not sure.
I think in this sentence they're talking about the law before that, though. I think they're talking about before safe harbor, because they say this result seemed to Congress unwise. They're talking about the past.
Yeah.
Okay, so yeah,
But they're citing a 2021 case, which isn't the past. I mean, because Congress.
That's why I think the 2021 site is not right. I think it's out of context.
Yeah, I think so too. Of greater concern to website operators were the copyright doctrines of indirect infringement, termed contributory or vicarious infringement. See La Resolana Architects, PA versus Reno Inc. One infringes contributorily by intentionally inducing or encouraging direct infringement, and infringes vicariously by profiting from direct infringement while declining to exercise a right to stop or limit it.
Yeah, that's why I was talking about it earlier.
Yeah.
Contributory libel, intentionally inducing, encouraging, soliciting, something a little bit more specific. It's like, yes, that is contributory. But if you just have a general website that's like, look at me, I'm a general website, that's not what we're talking about.
Right. And profiting from direct infringement while declining to exercise the right to stop it is Metro Goldwyn Mayer Studios versus Grokster. So you're talking immediately about an inherently profitable work, a Hollywood production of some sort, versus Grokster Limited. I don't even know what that is, but I'm going to guess that that's some sort of.
It was a peer-to-peer file sharing, like LimeWire.
Yeah,
Napster. It was something similar to that. Yeah.
Okay, so yeah, we're talking about the selling of something fairly directly, or selling ads on it. Because websites vicariously control and profit from what users do on them, and because websites influence, i.e. encourage, induce, and meaningfully contribute to what their users do, both direct infringement theories were of immense concern to website operators in the 1990s. This is a little broad to say that they automatically do these things. They do sometimes do those things, but not necessarily. In the DMCA's Section 512C to D, Congress offered website operators a chance at legal certainty. Under the DMCA, website operators could eliminate nearly all liability except for very narrow injunctive relief for the posting of infringing materials online by third-party users or the posting of links to infringing materials. The key catch was that the Section 512 safe harbors limitations on liability are conditional. To qualify, the website operators had to meet a number of conditions set forth by Congress. They, quote, must act expeditiously to remove infringing material that is known of. Although this isn't quoted, so kind of curious there. And then same for Section 512D's link posting safe harbor. Most pertinent to this appeal, to receive these conditional safe harbors, the website operators had to comply with a process called notice and takedown, conditioning third-party posting safe harbor upon responding expeditiously to remove or disable access to the material that is claimed to be infringing or to be the subject of infringing activity upon receipt of a DMCA notice. The elements of a DMCA notification are described in 512c3, and a key policy feature of the DMCA notice and takedown is its simplicity and user-friendliness. The simplicity of the contents of the takedown notice permits any person without a lawyer to easily notify a website operator of materials that are infringing. True. This limitation on liability was not an entitlement, but a compromise, a deal Congress broke.
What the fuck is this paragraph doing here? Who the fuck cares why Congress passed it? It's a statute now.
Yeah,
it's not entitlement, but a compromise deal. What the fuck is that? That's just like, it's just a view on why. Who cares? It's the law now.
Yeah, we're not going into the congressional intent here. We're not at that stage of interpretation. It's not ambiguous.
Also, for my money, I don't give a shit one way what congressional intent is. Just tell me what the statute says, you know?
Exactly. Congress brokered to help advance the interests of both copyright holders and website operators, giving the website operators limitations on liability in return for taking greater efforts at respecting the rights of copyright owners across the internet. In short, Congress carefully crafted DMCA safe harbors codified in 512C to D, reflected a threefold policy wisdom.
Ooh, Congress had policy wisdom. Okay, that's nice.
Website operators, impelled by the prospect of direct and indirect infringement, would comply with the conditions to receive the DMCA's limitations on liability, and in turn, the safe harbors would limit website liability. Copyright holders, empowered to obtain a quick remedy of a takedown for infringing materials, but limited in their remedies against website operators due to safe harbors, would rely on takedown for most infringements. The federal courts would play the role of ensuring website compliance with the DMCA safe harbor conditions, but would otherwise face limited litigation because both copyright holders could get infringing materials, because copyright holders could get infringing materials offline through takedowns, and because websites would only be liable for a limited scope of injunctions. The long and short is copyright actions cost hundreds of thousands of dollars, and most copyright infringements are worth significantly less than that. I mean, that's the translation of the wisdom of Congress.
They can do.
Critically, this appeal deals with the scope of indirect infringement online. Here, a website operator abused the DMCA process to encourage infringement rather than complying with it to get material taken down. And although the DMCA safe harbors are not directly at issue in this appeal, the underlying incentives for website operators are because it is the scope of a prima facie claim of infringement that incentivizes good faith compliance with the DMCA safe harbor conditions.
I don't even understand that sentence. What do you mean that DMCA offers are not the issue? Isn't that exactly the issue?
They're not suing under the DMCA. I think this is part of the problem with the case, is that I think the DMCA issues were raised as like a side issue and not failure to comply with the DMCA.
Yeah.
In general. But this is a very confusing paragraph. It doesn't make sense. The DMCA is not an issue here, but we've been talking about it for the past 2 pages because this is not
is this a philosophy class or a law class? Let me tell you the reasons that DMCA was passed by the Congress and why it represents an important balance in our intellectual property system. It all began in 1776 when the Congress first considered the Copyright Act.
By contrast, the narrowing of those indirect infringement doctrines, as happened below, undermines the safe harbor incentives that lead to compliance with the DMCA's notice and takedown process. This is a weird way. Like, we want you to enforce the DMCA by narrowing the scope of indirect infringement doctrine, or by broadening the scope of indirect infringement doctrines.
I'm not 100% sure what's going on right now. Yeah.
Yeah. Okay. So defendants here are the website and website operator Kiwi Farms and Mr. Moon, respectively. Their former Twitter handle succinctly gives a self-description of what the website focuses on: gossip and exploitation of the mentally handicapped for amusement purposes.
You do understand that is a troll and not to be understood literally, right?
No, I don't know that it is.
No.
I don't know
Okay.
that it is, frankly.
Okay.
Mr. Moon operates on Kiwi Farms through the profile name Null, and he appears to be a prolific contributor to the site with a screenshot of his profile avatar shown on the next page. There it is. There's Doggo Null. With a good quote. I made a mistake signing up to this shitty forum. I'm leaving. Yeah, he's got 21,042 messages. It's quite a few posts, but noticing that's going back to 2012. And he is the operator of the website. Mr. Moon is committed to the complete anonymity of the users on the site, committing to conceal them unless I am subpoenaed.
Okay.
Yep.
Cool.
The site has been the subject of a petition that would like Kiwi Farms to be shut down. This
Who
petition
the fuck cares?
after Kiwi Farms users relentlessly harassed 3 disabled women, leading to their deaths. Wait a minute. You don't just get to call them disabled. Like, you don't just get to say that they're disabled. Oh, my God.
Also, a petition to shut them down. What does that mean? I'm petitioning to shut this lawsuit down. What are we talking about?
Yeah, it's complete. This is all worthless claptrap, frankly. Now we've got Russell Greer. Let's hear the glowing characterization of Mr. Greer.
Mm-hmm.
There's a lot of petitions out about Mr. Greer. I hope they cite my 12-part series on why I sued Taylor Swift in this document.
That'd be good.
Mr. Greer is a person whom Kiwi Farms users and Mr. Moon have consistently harassed and targeted for about 5 years, in large part because Mr. Greer suffers serious physical and developmental disabilities. For example, his face is paralyzed.
Developed? Developmental.
Developmental. Did I say developed?
That's what I heard. Maybe I misspoke.
He's got developed disabilities, though, I think. A Kiwi Farms user readily admits that Mr. Greer is an extremely compromised person, but harasses him nonetheless. You might have a different idea of compromise than they do. Over the past 5 years, Kiwi Farms users have orchestrated a relentless harassment campaign against Mr. Greer that includes direct harassment via phone, no evidence of this, email, and social media. Schemes that successfully got him fired from his workplace and evicted. Again, no evidence of this. He got fired from his workplace by his own admission because they told him to stop suing Taylor Swift, and he refused. He was a paralegal who refused to stop suing Taylor Swift. Creating false social media profiles that impersonate him with names such as Mobius Shitlips, Ratface, and Rustard, names that mock his physical and developmental disabilities.
Not to put too fine a point on it, but how do you know that those names are mocking you unless you perceive yourself that way?
This is but a small listing of the relentless abuse and harassment that Mr. Greer has suffered from Kiwi Farms users over the years, all for cheap laughs and entertainment. I don't think that page does that, or that section does them any favors, honestly.
Here's a pro tip. Kiwi Farms, like many of its compatriots, are best ignored because you just give energy and it just distracts you. You just give them energy and fuel and just let them do whatever they're doing over there and just ignore them in the dark places.
Here's the thing about
go, Simba.
Kiwi Farms. The description, while it was joking, is accurate. It's a gossip website, which means people gather there to gossip. If Kiwi Farms is taken down or doesn't exist, people will merely gather at the next water cooler to gossip. People have been gossiping in places forever. That's people talk, and they will always talk. And you just by saying, well, you can't talk here, they'll go, all right, we'll talk here. That's the way life works. So there's really no purpose in trying to consistently shut it down. They're harassing me. First of all, I will say Kiwi Farms doesn't particularly harass people. They'll talk a lot of shit about people. Believe me, talking a lot of shit about me lately. It's fine. That's what they get to do. I'll never stop defending the right of people to talk shit. But they don't do much. Like they're not like coming to my house or making phone calls or doing anything to actually interfere with my life. And in fact, if I didn't know that Kiwi Farms existed, I wouldn't know they were talking about me unless someone tells me about it or something else. That's the way gossip ends up working, is that unless you're looking at it, it's just there. So
I certainly got a lot happier when I started ignoring the channels and stuff that were just talking about me. It's just like, get them out of my mind. I certainly got a lot happier. They're off doing whatever they're doing, and I ceased to stop. And I don't care. anymore because I don't know and I don't want to know.
Well, there's nothing you can really do about it anyway. Like you can spend a bunch of time like trying to do something, and what you're ultimately going to do is, like you said, you're going to feed into it, and it's just going to
I found it the hard way that was counterproductive. Yeah. And so I was like, I'll try something else.
The instant dispute. Okay. Whew. Here we are. We're at the case now. The copyright portions of this dispute, which form the heart of this appeal, stem from the posting of Mr. Greer's copyrighted works by Kiwi Farms users as part of their harassment of him. And they really need to stop with the harassment that is irrelevant to the copyright issue. It clouds the issue. It makes it look like I think it's counterintuitive, because I think it kind of looks like you think that this website is harassing you, so you're trying to enact power over it through some other mechanism. And if I'm a judge, I'm considering that. I'm going, okay, this kind of looks like you have a harassment issue, but you know that you've got a problem suing for harassment, so you're going to try and use copyright as a means, but you keep talking about harassment.
Right.
Kiwi Farms users posted a link to Mr. Greer's copyright registered book on Kiwi Farms.
And then you start thinking copyright abuse, right? Because this is basically Sargon of Akkad, right?
Right.
I'm not really complaining about copyright. I'm really complaining about something else, and I'm trying to use a copyright mechanism to do it. And now suddenly we're thinking about sanctions for copyright abuse under 512.
Yep. That's that could be a problem. But thankfully for us, they just asked for dismissal. Get out. Get out, you're done. Like, we don't want to deal with it.
How nice.
But listen to this, though. Kiwi Farms users posted a link to Mr. Greer's copyright registered books on Kiwi Farms. They didn't actually post the book. They didn't upload the work.
Yeah.
That makes it another step removed. Another step removed from the forums, but specifically, the user.
I'm not even sure that's copyright infringement under the relevant law. A mere link like that, that's something you don't host. Well, no, I'd have to go check the case law. That seems thin.
They mentioned up above that they mentioned a link, but I don't know that that's actually sorted out or settled law, that a mere posting of a link could amount to copyright infringement. I think in the DMCA safe harbor provisions, you can request the takedown of a link. But again, I don't think the link itself is copyright infringement. So I'm not.
Well, I mean, the link itself isn't copyright infringement, because the link itself is literally just an address, which is which is probably not copyrightable, and it's certainly not the copyrighted work. So yeah.
So Mr. Greer sent DMCA notices to Mr. Moon. Oh, they also uploaded a copy of Mr. Greer's registered song. Oh,
he has a song. Can we listen to it and can we listen to it and comment it for the purpose of critique? And
when we go to Rumble, I will definitely play "I Get You" Taylor Swift for you, Kurt.
Excellent.
I love this song. It's one of my favorite songs.
I recently did a full reaction on my channel to the Eliza Bleu rap video, and it was glorious. So I'm looking forward to this as well.
Oh yeah. Oh yeah. We may have to cover her rap. But it's hard to find now, though. I'm sure it's out there somewhere.
I have a downloaded copy.
Well, we might have to play it. Mr. Greer sent DMCA notices to Mr. Moon requesting that the book and song be taken down. Again, the book is not actually the book. It's a link to the book. Mr. Moon erroneously indicated that Mr. Greer's takedown notices were invalid. All right, so here we go. Here's a footnote. Mr. Moon seems to have erroneously believed that a DMCA takedown notice cannot be used to request removal of a link to infringing material that is hosted on a separate website, but see Section 512D3 permitting just that. Mr. Moon may also have believed in error that website operators can ignore takedowns if, in the website operator's judgment, an affirmative defense might apply, but see Section 512C1C requiring removal upon claimed infringement in a notice and takedown. Ultimately, such questions are not now before the court because defendants have not asserted Section 512 as a defense and may have waived it. See Appendix 259 Moon quoting.
I will waive whatever safe harbor protections I have. Okay, I'll do it. That's a nice thing to say. That's good. Why don't you just say I forfeit that? That'll be good too. Throw that in there.
He said that, I believe, in an email to. He didn't say that in court, but he said that, and I think an email to Greer, that he will waive whichever safe harbor protections he has. But interestingly enough, he hasn't waived them in the case, And apparently the safe harbor provisions aren't at issue in the first place. This was dismissed without consideration of them because the DMCA wasn't the issue, as they've told us so much. But do you know 512D3? That's the link one.
I'd have to look it up.
DMCA 512D3. Let me see if I've got it real quick. Okay, Cornell. 512B C D. Information
D's
location tools.
D's after C.
Upon notification of claimed infringement as described in subsection C, C3, responds expeditiously to remove or disable access to the material that is claimed to be infringing or to be the subject of infringing activity, except that for purposes of this paragraph, the information described in subsection C3A3 shall be identification of the reference or link to material or activity claimed to be infringing that is to be removed or access to which is to be disabled, and information reasonably sufficient to permit the service provider to locate that reference or link. So it looks like they can request the takedown of a link specifically.
Fine.
So here we go. Moreover, there is no serious question that Mr. Moon has the authority and capacity to control the content on Kiwi farms. Mr. Moon has admitted that he has the ability to take down content when he wishes. Again, that's irrelevant, completely irrelevant to whether he has a duty to do so. Nonetheless, instead of taking down the infringements in Mr. Greer's works, Mr. Moon posted the DMCA takedown request itself to the Kiwi Farms forums.
Typical.
By posting Mr. Greer's DMCA takedown notices there, Mr.
No.
Inducing his users to engage in further infringements.
No, absolutely not. Google even does this. They post the links to all the takedown notices.
Yes.
There's a link to the bomb, goes right to it for no. This is bullshit.
Correct. Infringements of Mr. Greer's works, as well as providing his users with direct links to the infringements contained in the DMCA notices. Well, because he says this post is the one that is DMCA'd or whatever, and you can direct people to it that way. So that's the statement of the case. Here's the proceedings below. Oh, I guess this is a little bit more backstory. Then we'll get to the oral arguments. After enduring years of abuse and concerted refusals by Mr. Moon and his site, Kiwi Farms, to remove infringing materials, Mr. Greer sought redress in court, sued defendants in the District of Utah. The Honorable Tenna Campbell, U.S. District Judge presiding, proceeding pro se, Mr. Greer asserted claims of copyright infringement and related state law claims. His goal was to put an immediate stop to and obtain redress for Mr. Moon's takedown refusals, among other harms, and Mr. Moon had invited Mr. Greer's suit. Mr. Greer's goal of getting works taken down is noteworthy. The DMCA notice and takedown process exists to avoid necessitating lawsuits over takedowns, but Mr. Moon refused to comply with Mr. Greer's takedown requests. Citing this thing, expecting strong incentives for service providers and copyright owners to cooperate to detect and deal with copyright infringements. Is this again Congress talking about Congress's intent?
Yeah, that's conference report. That's the conference from the House and the Senate when they were negotiating the language, which has no impact because it's just the view of the people who wrote it. It's not the view of Congress.
Right. Thus, Mr. Moon's intransigence left Mr. Greer without option but to proceed to court to try to get the infringements taken down. To try to get his works taken down, Mr. Greer moved for a preliminary injunction. He has a brief detailing a never-ending pattern of harassment. Again, you keep bringing up this pattern of harassment, which is irrelevant to copyright, and citing key cases on contributory liability, including Gershwin Publishing Corp. Versus Columbia Artist Management and Religious Technology Center versus Netcom Online Communications. For their part, Mr. Moon and Kiwi Farms filed a Rule 12b6 motion to dismiss. Their main argument was that Mr. Moon's inducement and encouragement of infringement took place after the book had been posted. Well, that's what you put in your complaint. Mr. Greer opposed and defendants replied. Also, Mr. Greer sought to file supplement briefs, which were denied. Some materials in Mr. Greer's proffered supplemental briefs evince improper incivility toward Mr. Moon's counsel. As a pro se litigant, Mr. Greer was unfamiliar with the norms of court proceedings, and he was being harassed by Kiwi Farm users who are using Mr. Moon's counsel's name. Scortus is going to blow your pipsqueak ass out of the water. Mr. Greer's appellate counsel has explained to him why assailing opposing counsel is both improper and outside the decorum for court proceedings. In response, Mr. Greer expressed contrition and committed that his behavior will not happen again. Okay. The district court granted the motion to dismiss, holding that Mr. Greer had failed to state a claim. And
This is
enter
like
judgment.
this is
defendant's
like
favor.
this is like in communications between them and like email between the two sides. Is that, or we're talking
I think
about court filings?
He might have posted something. He usually has court filings that have some sort of hostility to opposing counsel too. He's got a history with Greg Skordas also. I think he pissed off Skordas years and years ago because Skordas represented Taylor Swift when Russell Greer sued her in Utah. And I'm pretty sure, now I may be wrong on this, Russ, don't sue me for defamation, but my brain seems to remember that he commented on the very attractive looks of Greg Skordas' daughter in a case where he's basically suing as a stalker of multiple beautiful women that are very prominent. It was not the best move, Russ, to do that. So I think he has some animus towards Skordas. He doesn't like him. He's always disliked him ever since Skordas keeps showing up to defend people and crushing Russell Greer in court every single time. And I think Skordas gets a little bit of a thrill out of it. I think he likes it because of that whole daughter thing. For the copyright infringement claims, the district court held that Mr. Greer had made a showing of 2 of the 3 elements of contributory infringement, direct infringement by others and knowledge, but that Mr. Greer had not sufficiently alleged an act of inducement, encouragement, or material contribution. The critical act of contributory infringement is actually having the part where you contribute to it. For the state law claims, district court largely held that Mr. Greer had not alleged sufficient facts to demonstrate culpable behavior that was legally attributable to Mr. Moon. These are the harassment things and defamation. The one exception was the uncontested dismissal of the Utah Electronic Communications harassment claim because there is no private right of action for that claim. Right. You don't get to bring that. That's a criminal act. The district court denied leave to amend the initial pro se complaint, and given the holding that Mr. Greer had failed to state a claim, the district court held Mr. Greer did not demonstrate the likelihood of success necessary for preliminary injunction to issue. Then Mr. Greer sought reconsideration and sought leave to amend his complaint. District court denied both forms of relief. Notably, in denying reconsideration, district court suggested that Mr. Greer may well have had a plausible cause of action under the Digital Millennium Copyright Act, or even a claim for vicarious copyright infringement. Mr. Greer timely appealed. He has since retained public interest appellate counsel to prosecute his appeal before the court. You may have had these claims, but you didn't bring them. Appealing this action would be why don't you just? Well, he probably can't. He's probably got res judicata issues if he tries to file for these things because he should have stated them in the claim of the issue preclusion. Okay. So here we go. I don't think we need any more. Should we just go to the recording?
Let's go to the recording.
Okay. Let me pull it up real quick. And then I will also, we're going to grab some of these super chats here as well as we go. Hold on. I got to find this oral argument section from the court. Only Greer versus Moon. Perfect. Okay. So this is just under 30 minutes long. So it's going to take a few to get through it. Shoot, we might have to switch over to Rumble first for this because we're coming up on time. Let me do YouTube super chats, and then we'll switch over to Rumble. We'll do this court hearing, and then we'll do Eliza Bleu. Not like that, Eliza. Good Lord. Malik Foxon made chops and shrimp with fried zucchini and squash, and I learned how to make rutabaga fries. Just got to figure out how to make them crispy. Genuinely having fun navigating this diet. There you go, brother. Rutabaga fries? I mean, I guess. How to make them crispy? Okay, it's probably the same way you make regular French fries crispy. You fry them at a lower temperature to cook them through. You take them out, let them sit for a minute, and then you fry them at a significantly higher temperature later. That gets the crispiness on the outside after they're cooked through. The other way you could do it is you could either bake or parboil the fries first, and then you dry them thoroughly before you put them in a fryer. If you parboil them, then you dump the fries in a high heat afterwards. Those are the ways that I would think you'd crisp those up, but I haven't tried it, so good luck. Cretosis, hey Nick, I know things have been busy, but I wanted to recommend checking the Acerthorn lawsuits again. He's now suing Sid Alpha and demands Sid get the whole world to stop harassing him and face jail time for failing to do so. Yeah, I've seen some of the Acerthorn stuff, and that looks just flat out idiotic. That guy seems like a complete weirdo. But I'll consider looking into it again. It's something. Okay, we've got Ben. Oh shit, why did it do that to me? Ben Stanfill says, "Hey Nick, couple things quick. One, I turned 25 on Monday. Two, started a great job about 2 months ago. And three, been working out and eating less and dropped 20 pounds so far. Thanks for all you do, especially ranting where I can't. Cheers." Hey, happy birthday.
I've been working out too. I've been working out too and losing weight, and so congratulations. Join the journey. Become healthier.
Man, I was gonna
happier.
ask how that's been going.
It's been going great. Been
It's
logging
nice.
my workouts, and people have been commenting that I'm happier, healthier, and thinner appearing and stuff like that. So, progress is being made. We're heading in the right direction. Things
And
are
just
good.
the workout endorphins are just nice, right?
Yeah.
Like you just feel good. Like it sucks to go out and work out a lot of times, but when you do and you've actually done it, it's like, oh, that was nice. I feel good now. Peter Smith, Nick, you owe me and my newborn daughter a toast. You never delivered last night. Shoot, I'm sorry. Here's hopefully the last $20 I have to give you, lol. Now I know how your kids must feel. Aren't you my favorite alcoholic on YouTube? Did I got sidetracked after doing that? I'm sorry. Peter, happy birthday to your newborn, like legitimate birthday to your newborn daughter. And a cheers to you as a new dad. You're embarking upon a journey of wonderful discovery and intense frustration because you're having a girl. May your shotgun practice over the next 15 to 18 years be solid, and may you acquire enough land to bury any unsuitable suitors for your little angel. Cheers, brother. Enjoy it. Okay, Cult of Personality says, kind of crazy how divergent the opinions have been on the Crowder versus Daily Wire stuff across the people I usually watch. Not even a month in, and 2023 has been wild. Yeah, what did you think about that situation?
I did a video on it. Basically, my take was I thought that Crowder was dickish for releasing the call was my biggest criticism of the whole thing. I just didn't think that was really a proper thing to do. I understood recording it, but releasing it I didn't really approve of. Sure. And I understood where Daily Wire was coming from in terms of they're trying to play out a set of priorities. Purity of message and money being two of those priorities, among others, and how they deal with that. And Crowder is dealing with those priorities differently. But I don't think Crowder is as pure as he says, because he says, for example, that we should just be completely divorced from big tech, but he doesn't operate that way. He has a YouTube channel. It's not monetized, but it exists. Presumably, he sees some value in it as an advertising tool to help make people aware of him and make people aware of Mudclug. And he's not going out of his way to antagonize YouTube on the platform. I mean, YouTube can be antagonized no matter what he does, but he cites his sources. He cites his sources and he tries to play within the rules to keep the YouTube thing going. So I think to some degree he's kind of doing the same thing he's accusing Daily Wire of doing.
I think the difference in what Crowder does, one, I'll say there are times where it certainly looks like Crowder's aiming for that strike a little bit. And yeah. I don't know this, but I've heard that Bill Richmond, half Asian lawyer, has basically gotten to the point where he knows how to turn the screws at YouTube with an appropriate legal threat, and that mitigates a lot of the effects of the strikes that Crowder would suffer. But Crowder's main issue, the strike doesn't affect him as well because he's not monetized anyway on YouTube. So right. Strikes for him are a great PR tool. Like they're an excellent source of that. And he's gotten quite a bit of them, but they do get overturned with regularity. And I have heard that might be basically the skill that has been built up by his counsel. But I don't know. I can't verify that. But that being said, the difference is, for me, when what he's talking about, whether he's right or wrong, is that by Daily Wire including an enforcement mechanism in the contract that mirrors big tech, that's actually supporting big tech's enforcement against creators, that they are becoming an enforcement arm that big tech doesn't, or that amplifies, I guess, the enforcement that big tech would have for their policies. because if you violate and then YouTube slaps you down, now Daily Wire is doubly slapping you down by penalizing you under contract. And I think
I
that's
mean,
his point. Again, whether or not people agree with that, to me, that's
yeah.
where he's coming from.
And I think it's a fair characterization. And then from Daily Wire's point of view, it seems like the way that they're acting is they think that they can get out their message sufficiently purely while also playing within YouTube's terms of service and getting the revenue from that. So there is perhaps an exchange of purity of message for money, and they think that they are happy with that balance. And they would like the money because they want to do really expensive things like hire Gianna Carano and do this $100 million children's project and
Right.
hire all bunch of things. So they do massive documentaries and stuff. So they think their priority set is different than Crowder's priority set. And I don't think their priority set is necessarily wrong. It's just, and I don't think that they're wrong to say, well, we can play within these rules, get the money from that, use that for productive purposes, and still spread our message at the same time. Whether or not they're able to really succeed in all those goals, I suppose, is a little bit in the eye of the beholder, but it's not unreasonable for them to think so. Also, my other real criticism of the contract was Jeremy Boring, by his own words, said that they offered Crowder what they thought was the minimum to get the conversation started. They thought this was the bare minimum, which also contradicts Boring saying he's been our friend for 10 years.
Yep.
We love him. I've wanted to work with him every possible opportunity. We've talked over the years trying to find some way for us to get together. But I offered him the absolute bare minimum possible deal to get the negotiation started. I'm like, well, what is this? Is this an arm's length, quasi hostile transaction? Or are you guys friends? Because there's these two things are in tension.
Yeah,
It's
if I'm gonna hire a friend to do, like, someone I've befriended who says, "Hey, Nick, I could be your personal assistant or something," and like, yeah, we've been friends for a decade. I trust you. That'd be great. I'm gonna pay you the federal minimum wage.
yeah.
Like, that'd be insane. And they should be rightly insulted by that. And that's in a way what Boring and company did. Now, part of the thing I've tried to reiterate is there isn't an objective right or wrong in this scenario. The way Daily Wire is choosing to do business is perfectly valid. But I think Steven Crowder's criticisms of them in his subjective view are also perfectly valid, saying, I think the way you're doing business is a bad way for us. If we're really trying to build a movement, if we're trying to be something cohesive as a community, I think what you're doing is a bad way about it. So I think I tend to fall philosophically more on Crowder's side than Daily Wire's. I'm not saying that they did anything illegal or corrupt or whatever, but to me, I see his criticisms, and I think that they're valid. And I really think that the main thing is that Daily Wire just completely scuffed their response, in my opinion. I think Boring's video was an absolute disaster. I think Candace Owens was worse.
Yeah, Candace Owens is definitely the biggest loser in this entire exchange. I think we all agree on that much.
Yeah. And Ben Shapiro not far behind her, because his responses were rather spurgtastic too. Like, they were just, which is a shame, because Shapiro's usually like pretty solid on something. Well, except for the vaccine and lockdowns, but we're not going to get into what Shapiro's not been solid on, but and that wet ass pussy, because he's not really solid on that. He's not really sure what that means, which was interesting. But that was one of the better cell phones of all time. It was But aside from those things, he's decent, and he came across very emotional and kind of bitchy. So I kind of understood that part more, because he thinks the website was created, Stop Big Con was created some point substantially after the negotiations ended, but before this phone call, and he thinks the phone call was created specifically to try to bait them into saying things for the purpose of releasing it. So he thinks that he and his partner were set up, and so he's kind of pissed by that. So I understand that. Yeah, no, and we'll never know if that was Crowder's intent, or if Crowder had a CYA intent or whatever. I think what it looked like to me was Crowder really wanted Daily Wire. Like he told him, no, he counteroffered, and he expected a more reasonable counteroffer to come back from them. And after, almost 3 months, they didn't. And so he's like, fine, fuck you guys. That's kind of what I got the impression of. Mario Carter 13 says, if you've seen him, you'd know his specialty is oral. Talking about Russell Greer. That's true. Squizgar, did you see Yellow Flash caught a suspension because he posted a link to the Eliza Bleu video? Yep. It's crazy, like what's going on with that Eliza Bleu video.
Yeah.
Corn Pop, sorry, Nick, I'll slow down. Herbert the Pervert says, did someone say oral? Jake, Nick, you should do a live stream of Kyle's watch of Starship Troopers. Wait, what? Like Kyle Rittenhouse watched Starship Troopers? I'm very confused. Vanilla Honey says, sounds like Null needs Horatio for this one essay. Mr. Potato, you can fix anything with enough rope and helicopters. Eliza's Tesla has wooden doors. Hashtag Twitter Blue is for bingers, bikes, and wops. M169, if you haven't listened already, get over to Twitter and listen to the recording from tonight's Spaces with Project Veritas. Yeah, they're dropping some fire about some manipulation of various viruses. Doug Dimmadome, have you received a nomination for the 2022 Grifties Award, Nick? Google it if you haven't yet. No, I have not. I don't think so. I don't think I was in the running at the end. Corn Pop sent a sticker. John Crump Live, great content. Thank you. Vailned says, Twitter locked my account for sharing a Brittany Venti stream. United we stand, divided we fall. Welcome to Paralegal. Jackson Kai. They made that mistake when they first went after 4chan. If you blow up the manure barn, you get shit everywhere, so you ended up with more sites. Stitz 4, any chance we can get Monty and Greer to feud? God, that'd be funny. Jack Riley says, hi, Nick. Hey, Kurt. Gone to a Home Depot lately?
I did see that. Apparently I might owe someone an apology. Apparently that is a tactic to find women. I apparently stand corrected. Who knew?
I saw that and I died. I was like, oh my God. Matrix, love you. Please ask Flawedzilla on your channel. I will absolutely do that. The other thing I'm going to ask you guys to do is to check out birchgold.com/knows. My favorite gold company on the planet. Birch Gold is here to help you get gold and silver into your IRA or 401k. Now, most people think, oh, I can only like buy gold and hold it around, keep it, at my house or whatever. But you can actually hold it in qualified accounts, which is a really cool thing because you work, and this money, oftentimes for people with a 401k or some other qualified account like a 403b, we don't need to get into that too much. Your job is contributing to this. You're contributing to this automatically, and you're building up this nest egg over years. Well, that means that you might have a stack of cash that can actually buy gold and silver that you wouldn't normally have access to because, eggs are $5 for a frickin' dozen right now, which is insane.
That's what I'm saying. I mean, can Birch Gold help me buy eggs instead of gold? Because eggs seem like a better investment right now, to be honest. Can I get a 401? Can I get a 401 egg?
If you would imagine, so the double whammy is you've got the market crashing. So the value of your portfolio is going down and inflation rising. So the cost of eggs is going up. Well, when that happens, what gold tends to do is rise along with inflation as a purchasable commodity. The price of gold goes up with basically every other commodity. It's also resistant to the volatility of the market. So these big dips that happen, gold doesn't tend to drop in value. When you've got this double whammy, if you had invested in gold and silver beforehand, you could actually trade that in for quite a substantial amount of eggs. The impact of eggs would not have affected you so much. Now, of course, there's complications with a qualified account because you don't get to withdraw at your leisure and all that shit unless you're of a certain age. But that's what this is about. This is about fighting against that double whammy of the market tanking while you've got prices rising. That is the destroyer of savings. It makes savings effectively worth significantly less than they otherwise would be. And that might be intentional on the parts of our decision makers because having a consumer economy with almost no savings is very beneficial for control issues. But that's a question for another discussion. So fight the fucking government. Talk to birchgold.com/knows. Click on this green button. Get your free information about it so you can make the appropriate decision. I don't care if you buy gold. I don't care if you buy silver. I don't care what you do. All I care is that you have the right information from these guys to make that decision for yourself, because they can't make it. I can't make it. Kurt can't make it, even though he's really smart. Only you can know your risk tolerances, your preferences, and your investment strategies. So make it with all of the information that you can possibly.
Are they still doing that gold bill thing?
No, that was a Christmas promotion, and it's
Okay.
done.
Okay,
It's
that was
all
pretty
done
cool.
now. I know.
All
I like those. Those are fun. Those gold backs. I think you can buy them from them if you want, but they're not giving them away right now.
Okay.
Kyan Rennell says, loser must stolen election types butthurt by Daily Wire. Francesca 12, thank you for the donation. And Jackson Kai says, can I get golden eggs? Birch Gold should really get on that. Like, instead of doing bouillon, they're like, well,
The goose that laid the golden. Yeah.
let's do some golden eggs. All right, YouTube. We are going to wrap here on YouTube and move over to Rumble exclusively over to Rumble. So you can pop over there for the rest of the show. We'll be listening to this oral argument, and then we'll be discussing Eliza Bleu, and then we'll do What the Fuck Wednesday for a palate cleanser afterwards. The link is in the YouTube description. Pop on over to Rumble. There's over 8,000 people over there just waiting to give you warm hugs.
8,000.
Yeah.
8,000. Damn.
That's right. That's right. They're here to give you warm hugs and possibly lick your butthole. Look, I don't know what they're doing. I don't know what they'll do for you, but you can only find out if you go to Rumble. All right, guys, we'll see you over there. Otherwise, I'll see you for the Murdaugh trial. Or alternatively, you can check out my man Kurt's stream on the Murdaugh trial as well. He will be also offering plenty of coverage of that, and you can get some different sort of perspectives and opinions and ideas about what's going on if you check his channel out as well. So until next time, or until 20 seconds from now, peace. Peace.
For the thousands in attendance and the millions watching around the world, ladies and gentlemen,